Morning.
SJC-10078, Commonwealth versus Smith.
Morning, Counsel.
May it please the Court, my name is Stuart Graham, counsel for the defendant James Smith. This is Mr. Smith's combined appeal from his conviction for first-degree murder and from his denial of a motion for new trial. I'll address first point 1 of the brief, which involves Mr. Smith's motion for new trial, and then point 4, which addresses the constructive amendment to the indictments, leaving the remaining arguments for the brief. Initially, Mr. Smith asserts that the waiver of his right to testify was invalid. In Commonwealth v. Freeman, the court held that a defendant must show by preponderance of the evidence that but for his counsel's erroneous advice, he would have testified in his own defense. That decision is informed by 3 factors that focus on the defendant's state of mind. The first is the advice given by counsel regarding the decision not to testify. The second is whether but for that advice, the defendant would have testified, that is not waived his right. And third, whether the advice was erroneous, that is the quality of the advice. The crucial advice given here by counsel, acknowledged in his affidavit, which the lower court credited, was that if the defendant followed counsel's advice and did not testify, then he could challenge that advice post-trial and his decision not to testify.
And the defendant takes the position he understood that to mean that after the trial that he could then raise his claim.
That's correct. I mean, he basically followed the words that counsel told him. You can challenge us after trial. You can challenge my advice and your decision not to testify after trial. This is an inexperienced criminal defendant. He had never had a criminal trial before.
Isn't there a certain irony here that the defense lawyer says, if you don't testify, well, he says you shouldn't testify, it's a bad idea, and if you don't testify, if you're found guilty, you can always challenge your conviction by saying that I told you not to testify and you can get a new trial. And you're saying that advice was so bad that he's now entitled to a new trial.
That's correct, Your Honor. It's bad because...
It sounds as if the advice was pretty good.
The advice was pretty bad because...
But if it's so bad, then we should say that bit of advice was silly and frivolous because there's no chance that he's going to get a new trial on that ground.
It's bad in a different sense, Your Honor. It's bad because in order for a defendant, as the court held in the United States v. Wogan, in order for a defendant to make an informed, intelligent decision regarding waiver to trial, he needs to have full information. He needs to know, as the court said there, the downside risk of that advice. Their defense counsel told the individual he didn't have to testify, he shouldn't testify at his sentencing hearing. The court said it's not the strategy of not telling him to testify or not that's the issue. The issue is the defendant had to know the downside risk of that advice. There was, government could appeal in the downward departure, defendant would be resentenced. That's what happened. Here the downside risk is the courts are unlikely to grant a new trial and to hold a waiver of a decision not to testify invalid if it's truly voluntary. That's the risk. The risk is your chances are extremely slim of challenging this after a trial. Unless he knew that, according to Wogan, unless he knew that downside risk, then he could not make an informed decision not to testify.
Now, as a practical matter, if he had testified, your sister makes the point, then he'd have to explain how it was that he shot the victim 2 or 3 times, twice in the back of the head. Wouldn't that have, tactically, wouldn't it have made sense not for him to testify?
2 responses, Your Honor. First, that focuses on the strategy of whether to testify or not. That's not the issue. The issue is what he knew when he decided not to testify, that is, he needed to know the downside risk. One's ineffective assistance of counsel. The other is an informed decision to make a waiver. 2 separate issues, 2 separate focuses. Secondly, it was precisely because of that evidence that he had to testify. That is, the evidence, according to the Commonwealth, was after he shot the defendant in the neck, he fell, he walked over, straddled him,
Straddled
and
him.
shot him a couple times. So all the medical evidence shows that's not true. He shot once, and
Just clarify, please. You say he was shot once? I thought he was shot in the neck.
no, once in the back of the head. And
Only
in the
once?
neck. Yes.
Once in the neck,
And
once in the back of the head.
That's correct. So,
No, but he'd also have to explain how come he's stopping at a Dunkin' Donuts and making that bizarre comment moments before he goes into the house, won't he?
I think that was after he went in the house. And obviously, he had just shot somebody. So it's not an unusual thing.
That was after, I thought?
I believe
thought in
so.
the Commonwealth
I
brief
could
it
be
said
wrong on
before.
that, but I believe so. However, the alternative to this is to let that evidence go in unconfronted. That's conviction. He
Well-
cannot, I'm sorry, Your Honor.
I mean, you say that's conviction, but if part of it is he shot him once and you're arguing about whether the second shot was when he was straddling him or not, but part of this is felony murder, right?
That's correct.
So the second shot is somewhat irrelevant, isn't it?
The second shot is the one that killed him. The first shot did not. And
So is he thinking somebody else shot him?
no, there are two separate issues. One is deliberately premeditated murder, and one is felony murder.
Well, I understand that.
Yeah.
But if you just take felony murder, and it's an argument about where was he when that second shot happened, or are you saying somebody else shot that second shot?
No, he agrees he shot that the second time. The different issues, Your Honor. The first is his waiver of his right to testify. That's got nothing to do with what he would have testified at
But
trial.
you just said that was conviction because this was this unconfronted statement that he was straddling the victim.
That's correct, and that's in response to the court's question on that. But I want to make clear that the first argument, that is the waiver argument, has got nothing to do with what he would have said at trial. That's the harmless error analysis, and that's not relevant to the issue of waiver. On waiver it is, was counsel's advice erroneous, which we believe we showed it has been regarding the right to challenge, and but for that advice, he would not have waived his trial, his right to testify. That's pretty much uncontradicted in the trial. Given that, reversal is required. Now, to go to your point.
Didn't the judge, but I thought the judge said he did not give any credit to the affidavit. Isn't that right?
To the defendant's affidavit, but
Yes.
he credited counsel's affidavit, which said the same thing. That is, that's contained in counsel's affidavit. But I told him.
Yes, but it doesn't, what that doesn't say is that the reason that he didn't testify is because if he'd known the downside risk, he would have testified. That part is not what counsel said.
No, but that's what the court in Wogan said, is that when you give that kind of advice, you've got to tell them the downside risk. That's the law. That's not a question of fact that has to be developed by affidavit. That's the law. That's why that advice was erroneous, because it didn't contain that downside risk. So that's on waiver. With regard to your
I'm sorry,
question,
the downside risk being?
being that if it's a truly voluntary waiver, you're not going to be able to challenge it on appeal. What the risk is,
But you are.
well, I'm challenging that advice and saying that advice invalidated the waiver, yes.
But if he had testified, you would not be making this argument.
If he had testified, I would not be making this
So by
argument.
not testifying, he at least preserved this being the very first argument you make on his appeal.
But, Your Honor, you put the defendant in an impossible position.
Well, he was in a difficult situation.
He was difficult,
Before.
but frankly, Your Honor, is making it worse for him. Because if he follows counsel's advice, you're saying it's too bad. Whether it's wrong or not, you've waived it. If he doesn't follow counsel's advice, you're saying, well, you know, he's in a better position than if he had followed.
If he had testified, and again, if he had testified, how would he have defeated the armed home invasion, going to Judge Botsford's
Yes,
questions of felony
that's
murder?
where I was about to address that argument. Commonwealth has to prove an unlawful entry, that he was armed and intended an assault. Now, counsel put forth basically no defense to that. The issue of why he was armed, he could have addressed, but he could have addressed it also through Mr. Chow's testimony, which we discussed in the brief. That is, he had a legitimate reason from his point of view to be armed, not that he was going there to make an assault. The issue comes down to his intent. The only person that can address his intent was him. That is, without his testifying as to what his intent was, what he was going to do and why, armed home invasion basically was proven. That is, there was no defense put up to that. He had to testify. Telling him not to testify, where he would have given exculpatory evidence, basically is a showing of prejudice according to Owen versus United States. In Owen, the court held that if a defendant would have testified and given exculpatory evidence, not that he would have won, but just exculpatory evidence, but he didn't due to counsel's erroneous advice, that's prejudice. So that shows ineffective assistance. But anyway, here, Ms. Stark basically, in many respects, supported his account, that there was no invasion, that he was allowed in. There was no yelling or screaming by Ms. Higgs. When she looked out, she was not against the door. The victim was in the back room at the time of the knock, bagging cocaine.
Wait. I'm sorry. As I understood it, Ms. Higgs answered the door, and she was grabbed around the neck, and a gun was placed to her head.
That's what Ms. Higgs says. What I'm saying is Ms. Stark, who was in the apartment at the time,
Yes.
contradicted that.
So, and the jury had to accept that testimony?
Yes. They had to accept Ms. Higgs. They didn't have to accept Ms. Stark's testimony. What I'm saying is that would support, to some degree, what Mr. Smith would have said had he testified. That is, that's corroborative of many of the things he would have said. However, the issue of intent could be addressed by no one but Mr. Smith. That's why he had to testify. That's why that advice was erroneous. If he said, as he would have, and he said in his affidavit, look, I would have said, the only reason I was armed, as Mr. Chow would have supported had it been called, is because I've been threatened by these guys over a drug deal. I was carrying a gun for some time. I went there to talk to Ms. Higgs. I had no intent of an assault. What happened was I went in the apartment and I was accosted by someone coming from the back with a gun. Ms. Stark supports that. And that's what happened. That would not be an armed home invasion. That would defeat the felony murder issue. That's why that aspect is important. In my time, I'd like quickly, if I could, to address the constructive amendment of the indictment. There were 2 armed home invasion incidents presented to the grand jury, at Ms. Ibera's and at Ms. Higgs'
Can I just back up for a minute? Where would that leave you in terms of the premeditation?
The premeditation goes back to the issue that we argued in the briefing before, is that the Commonwealth's theory of premeditation was that he stood over him and shot him in the head. The forensic evidence makes that impossible. That would have been a side-to-side downward shot through the head, since he was lying on the floor on the left side of his face, as the photograph, the trial exhibit, shows. That would have been side-to-side. It's the only way that could have happened. The medical evidence, he was shot in the back of the head, the right side, going upward, forward to the left, lodging behind the left eyebrow. It couldn't have happened if he were lying on the floor. That is, the Commonwealth's theory is totally unsupportable and contradicted by the forensic evidence. Thus, there is no evidence of deliberately premeditated murder. With regard to the constructive amendment, 2 incidents of home invasion presented to the grand jury, 1 indictment returned without specifying which one. That's the same case in Commonwealth Barbosa and Commonwealth v. Munitz. The Commonwealth at trial selected which of those incidents it wanted to present to the jury. That's a constructive amendment of the indictment. That's clear.
And is there any claim that the defense counsel was surprised that that was the home invasion that was to be charged as opposed to the latter home invasion?
I think counsel preserved that issue by his motion when the constructive amendment was made. There's no requirement on the constructive amendment of a showing of prejudice. So it doesn't matter whether he was surprised or not. A constructive amendment requires reversal without a showing of prejudice. And that's what occurred here. That's Commonwealth Barbosa, Commonwealth v. Munitz. The Commonwealth argues that...
Correct me if I'm wrong, but the prosecutor says in effect that the because it would be the home invasion of Ms. Higgs' apartment that leads to the felony murder, that it had to be that.
I know they argued that, but that's illogical and
Why is that illogical?
and unfactual, because there is no evidence that the grand jury was advised of felony murder. There was no evidence that the grand jury was said, your home invasion, and the felony murder have to be linked. And this court said, Commonwealth doesn't have to put its theory of murder in the indictment, and it doesn't have to advise the grand jury of the elements of the offense. There is no evidence the grand jury was ever informed or advised of felony murder or that home invasion was a predicate offense. Thus, in this case, we don't know the incident on which the grand jury returned this indictment, and we can't speculate as to that. This is the same as in Commonwealth v. Barbosa and Commonwealth v. Muniz. Mr. Smith possibly was convicted of a crime that was not subject to the indictment. What happened at trial? Whether the evidence at trial supported this or not is irrelevant. It's not what happened at trial, not what the jury could have found. It's what the grand jury did or did not do. That's the issue. This was a classic constructive amendment. In closing, I would just say that Mass General Law 277-47A, which requires a pretrial motion to attack defects in the indictment, doesn't apply here for two reasons. First, if it did apply, it was waived by the Commonwealth. They're not raising it below or in this court. But secondly, the focus here is not on something that happened pre-trial. The focus here is on what happened at trial. That is, the constructive amendment occurred at trial. When it occurred, objection was made. That requires reversal without regard to prejudice. For these reasons and for the reasons stated in the brief, Your Honor, we ask the court to reverse the conviction and to order a new trial. Thank you.
Counsel.
Good morning, Your Honors. Karen Carlo for the Commonwealth. Your Honors, there's been no constructive amendment in this case. Logically, if the grand jury indicted the defendant on felony murder, as they did here, they would have had to have found that the armed home invasion was the one that occurred where the murder occurred.
Why did you not, or whoever presented it to the grand jury, why didn't you put it as either two separate indictments, or, why even create a possibility of confusion here?
I can't speak for the prosecutor who presented the case to the grand jury, but I believe there was the evidence that there was a home invasion at the murder scene, and it was very clear that there was an armed home invasion that occurred there. I think at the grand jury, there might have been conflicting testimony as to how the defendant entered the other address. So it might not have been clear that that was...
The clock. Oh, thank you. I'm sorry, Counsel.
So it might not have been clear that there was actually an armed home invasion.
The second one at Ms. Ibarra's.
The second one at Ms. Ibarra's.
So you think, I haven't read the grand jury testimony, but is it your point that if you read the grand jury testimony, it would be, as a practical matter, clear that what the grand jury was indicting for was the Higgs armed home invasion?
Possibly.
Is that just as a matter of logic because it's connected to the felony murder?
It's just as a matter of logic as connected to the felony murder, truthfully, because if you were to look at the grand jury testimony and you wanted to say, could I find a crime here, you could. But I think that as a matter of course, the prosecutor during the grand jury, he must instruct the jury on felony murder. And so it's just a logical conclusion that the armed home invasion that occurred at Secor Ave formed the predicate for that. Your Honors, I'd like to address the argument that there is no forensic evidence of premeditated murder. My counsel argues that it's logically impossible in this case that the victim was shot in the back of the head as he lay on the ground with the left side of his face facing forward. The defendant, in his affidavit now is claiming that had he testified, he would have testified that he shot the victim twice in quick succession as the victim was coming at him, shot him in the neck, which turned him around, then he shot him in the back of the head. In support of his motion for new trial, the defendant submitted some affidavits and reports from a ballistician who testifies or who avers that the murder could not have occurred in the way that the Commonwealth's witnesses described it. Now, this expert is a ballistician. He's not a pathologist, so he's a firearms expert. He's not an expert as to line of fire or what happens when a bullet enters a person's body and passes through their brain and bone matter. So I would argue that the evidence in support of the defendant's theory that there could be no premeditated murder because the evidence doesn't support it is speculative.
Well, do you dispute what your brother says, that the bullet entered through the side of the head and came out?
I do not dispute that, Your Honor. That's what the medical examiner testified, and but I argue that it's completely possible that the victim was shot as the witnesses described it, and that's the entry, or that's the line that the bullet took going through the body. We don't know exactly where the defendant was standing when he shot him in the back of the head. We don't know the angle that he was holding the gun.
Well, the testimony was he straddled the victim, right?
Right. But the Commonwealth's asserting that the angle of the bullet as it went in, as it was fired from the gun and went into this man's brain would depend on exactly how high or low or at what exact angle that this gun is being held. Also, was the defendant moving when he shot him? It's just our contention that this...
How was it presented at trial?
It was presented at trial that the defendant enters Miss Higgs' apartment, grabs her around the neck, holds a gun to her, throws her up against the wall. The victim walks towards the defendant because he's trying to walk by him to get to a door to leave. That the defendant then lets go of Higgs, shoots the victim in the neck. The victim falls, and then the defendant straddles him and shoots him in the head.
Now, was that based on eyewitness testimony, or was it based on a prosecutor's inference and argument?
That was completely based on Patricia Higgs' testimony, as well as Jeffrey Pontier's testimony. Jeffrey Pontier was
Boyfriend of Miss Stark, is that right?
Miss
Higgs's.
Fiance, who was in the other room, and testified that once he heard a shot, he then looked, and that's when he saw the defendant shoot him in the back of the head.
The medical examiner, I assume, testified as to the path of the bullet?
He testified as to the path of the bullet.
And what did he say, or she say?
Basically, Your Honor, the medical examiner just testified that the bullet entered the back of the brain and took, the path it took. I don't believe the medical examiner testified that means, that's consistent with the defendant standing in this exact spot and shooting him, from this exact spot.
But usually there's a chart, and usually there's sort of an arrow drawn to indicate the bullet's entry and the bullet's exit, or the bullet's location. Was that done in this case, do you know?
Not that I know of. I've only seen the medical examiner's report. Maybe I haven't seen it all, but I have not seen anything of that nature in this case. I'd also like to address the defendant's argument that he had no defense to felony murder without testifying. Well, this is I would assert, very strong Commonwealth's case. As was discussed.
But was the jury, I was looking at these dates, was the jury out for 2 weeks? I mean, there was something printed that the trial ended on, I'm going to say July 19th, and the jury came back on August 2nd. Was that right?
I don't believe so, Your Honor.
It's in the, it's on page 1 of the defendant's brief. It says that the case went Oh, went to trial. Sorry, I was thinking it was went to the jury. Okay.
Okay. As was mentioned earlier, the defendant in this case did go to Dunkin' Donuts before the shooting and ask the clerk at Dunkin' Donuts whether she would telephone the police if someone was shot. Now, counsel in this case informed the defendant, this is what counsel bears in his affidavit, I informed the defendant that the jury would not believe his reasons for why he went armed to Miss Higgs's apartment. The defendant now claims in his affidavit that I would have testified that I went to the apartment to speak with Miss Higgs. That would not have been believable based on the fact that Miss Higgs and the defendant were apparently in conflict because the defendant had been selling drugs out of her apartment for a few weeks, and she kicked him out of her apartment after she had an altercation with one of his clients. So he leaves, and then members of the defendant is a Crip. That's what the evidence proves. After he leaves, members of the Bloods move into the apartment, start selling drugs from there. A member of the Bloods. I believe his nickname was G Money. Members of the Crips, the defendant's gang, come in and assault G Money and Miss Stark. They hit him in the head with a gun, they steal money, they steal drugs. They leave. Another member of the Bloods, which is the victim, that's also a rival member of the defendant's gang, moves in. So at this apartment, there's already been violence between the two gangs over the drug territory. So it's not believable. It would not have been believable to the jury that the defendant went there simply to just talk to Miss Higgs, armed with a gun.
But what did the defense have in the absence of his testifying? I mean, what was the defense in this case?
The defense was self-defense. That's based on the fact that after the murder, a gun was found lying next to the victim. So the evidence that he was armed, although neither Miss Higgs nor Miss Stark saw the victim with a weapon. So it's inferable that the weapon was in his pockets and the weapon was removed from his pockets.
Now, by the way, referring to his pockets, if I understand it, after the victim was shot and was dead, Miss Starks and Miss Higgs went through his pockets, took out money and drugs before calling the police.
Yes, Your Honor, that's exactly right. That's after the evidence, if they're to be believed, that the defendant went through the victim's pockets first.
Well, I guess the question is, in terms of the strategy, what did he have to lose by testifying? I mean, he had a very thin read of a self-defense instruction without testifying. Why was it not counsel being ineffective for advising his client to not testify when he had almost no chance of prevailing unless the jury did believe him?
That's basically, I think the defendant's chance of being found or being acquitted in this case would just be through his cross-examination of the Commonwealth's witnesses and hope that Miss Higgs, whose credibility was pretty low based on the fact that she was a drug user and she was a drug dealer and she went through the victim's pockets after his death, that she would not be believed. And also, a lawful entry could have been based on Stark's testimony that she just heard knocks on the door and then all of a sudden the defendant was in there. She didn't testify that, I heard yelling or any type of commotion. The defendant's defense to felony murder is pretty slim, just based on the facts, just based on the statements he made before he went to the apartment, the animus between the two street gangs. Had he testified, he would have been cross-examined about the statement he made to the clerk at Dunkin' Donuts. He also would have been cross-examined. I would also like to add the defendant's statement to Ibarra and Mr. Caesar supported his theory of self-defense as well, because he testifies that I shot him because he was coming at me with a gun. But also, had he testified, he would have been impeached with his other statement to Mr. Caesar and Miss Ibarra, which was that I went in and I shot him, and then when he fell, I shot him in the head, and that was because he's in there making money and I'm not.
Didn't that come in, though?
That information came in.
So it's going to come in anyway.
That's true. That's true. But the prosecutor would have been able to just repeatedly question him about the gunshot to the back of the head, and believe the defendant really has no defense to that. As I've argued, I think the forensic evidence does support the Commonwealth's case.
Was there any other forensic evidence, such as stippling on the floor or anything like that?
No, there was not. And
were there any tests done to that effect?
I don't think there was any tests done regarding the floor, but I think when the medical examiner examined the victim's body, he looked for defensive wounds, powder tattooing, and things of that nature. And the defense now argues that he couldn't have been shot, as the Commonwealth argues, because those shots would have been contact or near contact wounds, which would have left powder tattooing or powder on the victim. And it's a Commonwealth's assertion that these shootings could have occurred in a manner that would not have left powder tattooing or anything of that nature, because the medical examiner testified something along the lines of the least amount of distance that must have been between the shooter and the victim where no powder tattooing or marks would be left is approximately a foot and a half away.
Even if you're pointing downwards, there wouldn't have been anything on his coat or clothing? Was that the testimony or the
on
opinion?
the defendant's coat or clothing?
No, on the victim. If you're shooting downward at a victim, there would have been no. Is there expert testimony that there possibly would have been no, tattooing even on his clothing?
No, there was no testimony that there would be nothing on him.
Was there any testing done on his clothing?
I don't believe so, Your Honor. But I think it's reasonable that the defendant could have shot him from, there's no testimony as to the exact distance between the victim and the shooter. So the defendant could have shot him from more than a foot or a foot and a half away. Or, we understand that he did straddle him and shoot him in the head, but there were no measurements as to how far away he was.
If I could turn briefly to the threats on the television. Is there any evidence that he was responsible for that? He was in custody. Telephone calls would have been monitored.
Right.
Why is it a fair inference that he bears responsibility for those threats?
I think the Commonwealth argued that it's just a fair inference based upon the gang activity and the animus between the two gangs, and the fact that these threats occurred after Miss Ibarra provided a statement to the police. In the past, the Crips had retaliated after.
But isn't that blaming the defendant for actions? Just assume for argument that he's a member of one of these gangs, but isn't it blaming him for some activity that maybe the gang is responsible for, but why is that necessarily his problem?
I think it can be attributed to him in a sense if you can infer that he consented to the threats or ratified the threats.
But how do you infer that? He's in custody, right?
Yes, Your Honor.
And as Justice Gant says, and his phone calls are being monitored.
Well, it's our argument that there's just an inference based on his involvement in a gang that they all consent to and ratify each other's activities.
And you would say that relates back to the animosity that was ongoing between the two
Yes, Your Honor.
gangs related to the apartment and
Yes, Your Honor.
and the feuding and all.
Yes, Your Honor.
Uh-huh.
And if this court were to find that that threat came in improperly, that the Commonwealth shouldn't have been allowed to introduce that, I think this court can find that the prejudice the defendant suffered by evidence of that threat coming from his gang was low, in particular because the defendant never denied that he was part of a gang. And I think in arguing against this evidence coming in, trial counsel said, something along the lines of, there's no dispute that he's a Crip.
Okay, so is it your view that if somebody is accused of a crime and is in custody and does nothing to encourage the threat, but the gang he belongs to threatens the witness because, after all, he's a member of the gang and the gang protects its own, that that's sufficient to admit it against the witness? I mean, against the defendant?
That's the Commonwealth's assertion in this case.
Well, what if they kill the witness? What if a gang member killed the witness? Under the same theory, could they charge the defendant with joint venture just because he was a member of the gang?
I don't think so, Your Honor. I think there has to be some evidence that he aided and abetted.
Well, wouldn't that be the same as this, though? I mean, theoretically, I understand one's a lot more serious than the other, but why are they different? Why can you attribute one to the defendant but not the other?
That's a tough question. I think I can't really answer this. I think to the court's satisfaction. I think that I just have to say in this case that any prejudice he suffered by that threat in light of this powerful evidence of premeditated murder was slight. There are no other questions. The rest of my brief. Thank you.
Thank you.